What if I told you the family immigration process you've been relying on for years could be entering a whole new era, starting right now? Across the country, thousands of families are waking up to a tougher reality. Bringing a loved one to the United States may become more complicated, more expensive, and a lot slower than people expect. In January 2026, the Trump administration signaled major changes and a stricter approach to how family-based immigration cases, especially Form I-130, the family petition, may be reviewed and processed. And whether you already have a case pending or you're planning to file soon, what happens next could directly affect how long your family stays separated, what evidence you'll need, and how easily USCIS can delay or deny your petition. Welcome back. You're watching Immigration Newsroom. I'm your host, and on this channel, we break down the immigration updates, visa changes, and policy shifts that can directly impact your future in the United States. Today, we're getting into the latest developments affecting family-based immigration and the I-130 process, what's changing, why it matters, and what you can do right now to protect your case and your timeline. Quick note before we begin, this video is for education and news-style discussion only. Immigration cases are extremely fact-specific, and rules and interpretations can change fast. Always verify updates through official sources and consider speaking to a qualified immigration attorney if your situation is complicated. Now let's start with the foundation. What is Form I-130 and why is it so important? Form I-130 is officially called the Petition for Alien Relative. It's the starting point, the gateway, for many family-based immigration cases. It's how a U.S. citizen or lawful permanent resident asks USCIS to recognize a qualifying relationship with a foreign family member, like a spouse, a child, a parent, or certain other relatives. When USCIS approves the I-130, that approval does not automatically give your family member a green card by itself. What it does is confirm that the relationship is real and qualifies under the immigration rules. After that, your relative generally moves forward either through consular processing abroad, working with the National Visa Center and a U.S. embassy or consulate, or, if eligible, through adjustment of status inside the United States to apply for a green card without leaving. The I-130 covers immediate relatives of U.S. citizens, like spouses, unmarried children under 21, and parents of adult U.S. citizens. It also covers family preference categories, like siblings of U.S. citizens and certain adult children, categories that are limited by annual visa caps and often involve long waits. For decades, family reunification has been a central part of U.S. immigration policy. Millions of people have used the I-130 process to reunite with their loved ones legally. But what we're seeing in early 2026 is a shift in tone and enforcement priorities that could reshape how these petitions are handled in practice, especially in terms of scrutiny, evidence, financial sponsorship, and how aggressively USCIS questions credibility. So what are the biggest changes families need to prepare for? First, expect increased scrutiny and heavier documentation requirements. In straightforward cases, people have historically filed an I-130 with core documents, birth certificates, marriage certificates, proof of the petitioner's U.S. citizenship or green card status, and moved forward. But under an enhanced vetting approach, even routine family petitions may trigger deeper review. That can mean USCIS asking for much more evidence than people are used to. For marriage-based petitions, officers may expect stronger proof that the relationship is genuine, ongoing, and not entered into just for immigration benefits. That can include a full relationship timeline, more proof of shared life and finances, more photos over time, travel records, messaging or call history, affidavits from people who know you as a couple, and clearer explanations of how you met, how you married, and how your household operates day to day. For parent or child cases, it can mean more careful review of documents, name variations, translation quality, and whether records are consistent across countries and systems. If your family's documents come from countries where record-keeping isn't uniform, you may need to be more proactive about certified copies, official corrections, or secondary evidence. If your documents are not in English, expect more attention on translations. Poor translations, missing certification language, or unclear formatting can quickly lead to delays or requests for evidence. In real life, This means the I-130 package may become more time-consuming and more expensive to prepare. Families may pay more for certified translations, document retrieval, and professional guidance. And even when you do everything right, processing times can rise simply because officers are spending longer reviewing each case and issuing more RFEs. Second, expect tougher financial sponsorship review, especially around the affidavit of support. A lot of people misunderstand this part. Filing the I-130 is about proving the family relationship, but to actually get the immigrant visa or green card, most family-based cases also require Form I-864, the affidavit of support. That's where the sponsor commits to financially support the immigrant so they are not likely to become dependent on certain public benefits. Traditionally, the sponsor's required income is tied to a percentage of the federal poverty guidelines, often discussed as 125%, depending on the household size and situation. If a sponsor didn't meet the income requirement, many cases relied on a joint sponsor, especially when the petitioner was early in their career, self-employed, recently changed jobs, or supporting a large family. The concern in 2026 is that financial standards may tighten through policy changes, interpretation changes, or stricter adjudication practices, meaning higher expectations for sponsor income, more skepticism about assets, more emphasis on stable and documentable earnings, and possibly less flexibility in practice even when joint sponsorship is technically available. If income expectations rise, that can hit working-class and lower-middle-class families the hardest. And even if the rule itself doesn't change overnight, a stricter review culture can still make approvals harder if your documentation isn't strong, especially if the sponsor's income fluctuates, is partially cash-based, or is difficult to verify through standard tax and payroll records. Third, expect expanded grounds for denial and increased RFEs. An RFE is a request for evidence. It's when USCIS tells you, "We can't decide yet, send more proof." The issue is that RFEs create delays, and if your response is weak or late, it can lead to denial. Under a stricter enforcement posture, officers may be more likely to question issues that previously would have been resolved informally or overlooked if they were minor. Things like inconsistent addresses, small date mistakes, different spellings of names, missing prior marriages or divorce details, missing proof of termination of prior relationships, incomplete travel history, or unclear explanations about how you and your spouse met. These things can become bigger problems when scrutiny increases. And for marriage cases, USCIS may take a harder line on what they view as red flags, even when relationships are real. Large age gaps, short courtships, religious or cultural differences, long-distance marriages, prior immigration filings, or unusual living arrangements can all trigger deeper questioning. None of these automatically mean denial, but if you don't document your case well, they can lead to heavy delays and intense interviews. Fourth, family preference categories may face longer waits, especially if visa bulletin movement slows. This part is critical. Even with an approved I-130, many family members cannot move forward until a visa number is available. That availability is controlled by the visa bulletin and the priority date system. Your priority date is essentially your place in line, usually the date USCIS receives your I-130. Immediate relatives of U.S. citizens generally don't face the same visa number waiting line, but preference categories do. Siblings of U.S. citizens and certain adult children categories can face very long waits already, especially for high-demand countries. If visa bulletin advancement slows down, or if policy choices indirectly reduce the number of visas moving through certain categories, families can end up waiting even longer, sometimes years longer than expected. That's why I-130 approved doesn't always mean coming soon. For many families, the I-130 is just step one, and the line after that is the real battle. Fifth, adjustment of status cases, especially for immediate relatives inside the U.S., may face stricter review. Many families file an I-130 for a spouse or child who is already in the United States, sometimes on a tourist visa, student visa, work visa, or with a complicated status history. Immediate relatives of U.S. citizens often have pathways to adjust status that are not available to other categories. But in a stricter environment, USCIS may be more aggressive in reviewing unlawful presence issues, prior overstays, and allegations of misrepresentation. For example, if someone entered the U.S. on a visitor visa and quickly married a U.S. citizen, USCIS may look closely at whether the person had a pre-existing intent to immigrate at the time of entry. That doesn't mean every case like that is fraudulent, but it does mean families should expect tougher questioning, more interview scrutiny, and a higher risk of delays if the paperwork and timeline aren't well explained. Now, let's talk briefly about what this could mean for specific family types. If you're a U.S. citizen sponsoring a spouse, you should prepare for heavier evidence demands, more detailed interviews, and deeper questioning about your daily life, finances, communication, history together, and future plans. The goal from USCIS is often to test whether your relationship story is consistent, natural, and supported by evidence. If you're a U.S. citizen sponsoring parents, expect careful document review and expect USCIS to look closely at any prior immigration history your parents may have: old visa refusals, overstays, removal orders, misrepresentations, or previous applications. If you're a lawful permanent resident sponsoring a spouse or unmarried children, you're dealing with preference category timing, and you may also face scrutiny on whether you're maintaining permanent resident status properly, especially if you've been outside the U.S. for long periods or have complicated travel history. And if you're filing for siblings, this category is already one of the slowest. There has been political discussion in the past about restricting or eliminating certain categories, and while changes to the sibling category would typically require Congress, the fact that it's discussed at all signals the general direction of debate. Even without formal elimination, slower visa movement or tougher processing could still make the sibling route feel even more out of reach. So what can you do right now to protect your case? If you plan to file an I-130, filing earlier can matter, because the priority date is locked the day USCIS receives your petition. Waiting can cost you months, and in backlogged categories, months can turn into years. Also, stop thinking in terms of minimum required documents. In a stricter climate, minimum filings can lead to maximum delays. A strong petition package is organized, consistent, and evidence-rich. That means clean copies, clear translations, a logical timeline, well-labeled proof, and no missing basics like divorce decrees, name change records, or proof of citizenship or residency. Be obsessive about accuracy. Small mistakes can now have big consequences. Double-check spellings, dates, addresses, prior marriages, prior entries, and anything that appears in multiple places across different forms. If something in your history is complicated, don't hope USCIS won't notice. Explain it clearly and document it. Plan early for the financial side. Keep tax returns, W-2s, pay stubs, employment letters, and evidence of ongoing income organized. If you may need a joint sponsor, don't wait until the last moment. And if you're relying on assets, be prepared to document that they are real, owned by you, and liquid enough to count. If you receive an RFE, treat it like an emergency. RFEs often have strict deadlines, and a rushed or incomplete response is one of the fastest ways to get denied. Answer every point they ask for, provide clean and relevant documents, and include a clear explanation letter that ties everything together. And yes, consider professional help if your situation is risky. Not every case needs an attorney, but some cases absolutely do. Prior immigration violations, prior denials, complicated marriages, prior removal issues, criminal history, name discrepancies, missing civil documents, or anything involving misrepresentation concerns. In a tougher enforcement environment, having a strategy can make the difference. Also remember this: if an I-130 is denied, there may be options: appeals, motions to reopen, motions to reconsider, or refiling with a stronger package. But those steps are technical and time-sensitive. The best path depends on the reason for denial and the facts of your situation. Finally, stay informed but stay smart about where you get information. Immigration policy can move quickly, and rumors spread faster than real updates. Rely on official announcements, reliable reporting, and careful analysis, not "someone told me" advice. That's exactly why Immigration Newsroom exists, to translate complicated immigration shifts into practical guidance you can actually use. If you filed an I-130 before any new standards take effect, understand that stricter review can still show up in pending cases through RFEs, interview scheduling patterns, and how officers interpret evidence. So even if you filed months ago, your job is not over. Stay organized, check your mail, update your address with USCIS if you move, and be ready to respond fast if they ask for anything. And one more thing, family-based immigration isn't the only option. Depending on your situation, there may be employment-based strategies, humanitarian pathways, or other legal routes that fit better and move faster. Each one has trade-offs, but knowing all your options can protect your long-term plan. I want to be honest, this tightening trend can make family immigration harder. It can mean longer waits, more denials, and higher financial barriers. But families still succeed every day. The families who succeed are usually the ones who prepare early, document heavily, stay consistent, and respond quickly when the government asks questions. If this video helped you understand what's changing and what to do next, hit like, share it with someone who's filing an I-130, and subscribe to Immigration Newsroom so you don't miss the next update. Turn on notifications too, because immigration policies can shift fast, and timing matters. Drop a comment with the topic you want next, because I read the comments and I build these videos around what real families are going through right now. This is Immigration Newsroom. Stay informed, stay prepared, and don't give up on bringing your family together. I'll see you in the next video.